Good evening, thank you. I'm doing very well. Good evening. I hope you had a slightly relaxed Sunday, but I know for you guys it's slightly difficult at the moment. Okay, now we will continue with right to privacy where we had left off day before yesterday. Let's continue with that topic. Now, before that, a lot of you have sort of written to me, emailed me with respect to the governance course. You've also reached out to me with respect to current affairs, with respect to internal security, international relations, some tests, case studies, ethics. I've taken all of that into consideration, and I'm going to be releasing the annual education plan for 2022. This is my pseudo way of feeling cool by calling it synonymous to the budget, but a man's got to do what a man's got to do. But I will release all of it. None of it will ever be on a chargeable basis ever. You know me, and you know who I am and what I stand for. So I'll take care of all of this for you. Don't worry about it. Just give me time till tonight. I will release the necessary details for all of you today itself. Right? Anyways, so let's continue with our class. We are going to be looking at the right to privacy. We had discussed certain elements of it. We are going to now get into very specifically the implications of right to privacy post the Puttoswamy judgment. What we were able to very clearly understand in our class day before yesterday was the fact that right to privacy per se only starts post the Puttoswamy judgment. We are also able to understand that the whole discussion on right to privacy starts with the advent of the Puttoswamy judgment. The Puttoswamy judgment per se doesn't make any change per se to the privacy ecosystem, but that judgment, it can be the basis of several other social issues, cultural issues, gender related issues to be solved, right? So let's look at it. Let's understand what is it that we are referring to. Okay, all right, so let us start. All right, the right to privacy. Let's start. Thanks, Tashi. Thank you. Yes, Atul, I will release the guidelines. Let me go through the notifications myself. So, very interestingly, while privacy also is a legal concept, it is something that has tremendous application to law. Privacy is something which also has a deep understanding with respect to ethics as well. Now let's understand why that is the case. That is the case because if morality is subjective, if morality is relative, so are the contours of privacy. What may be an invasion of privacy for you may not necessarily be an invasion of privacy for me. Like, let's look at it this way. Like, for example, all of us growing up have had these kind of arguments or these discussions with our respective parents, that the parents, for example, for some of you may, open your wardrobes or open your belongings to just rearrange them, right? But you would find that as an invasion of your privacy. They would not. In their view, what they're doing is reorganizing your space where you are living in. But what you think of it is a distortion of how things are for you. So if morality is subjective, that is also why privacy is subjective. And that's also one of the reasons why you have no universally accepted or a consolidated kind of a legal definition of privacy. But general understanding of privacy makes us understand that it refers to any mode by which people, personal information, certain personal property, and personal decision making can be made less accessible to others. It's about securing your private space, your personal space, and whatever constitutes your private space or your personal space, which is why it is often considered a human right, a natural right. Now, in India today, post the Puttaswamy judgment, it is undoubtedly a fundamental right under Article 21 due to the 2017 Puttaswamy judgment. Now, right to privacy can always be understood as constantly evolving and therefore is often determined on a case-to-case basis, right? Is often determined on a case-to-case basis. Let us now understand the broad implications of the right to privacy. Now, in the mains exam, if they ever ask you, now they've already asked a question like this, which they've asked as what are the implications of the judgment. But if they ask you, then you could probably structure your answer in this way. Your introduction could be that the right to privacy is now recognized as an implied fundamental right, primarily relating to Article 21, but also correlations to 19 and 14 because of the 2017 Puttaswamy judgment. Then your introduction closes, and you could also say several international documents such as the Universal Declaration for Human Rights or the International Covenant on Civil and Political Rights also recognize the right to privacy. Now, to identify the contours of privacy, to identify the meanings and the dimensions of privacy, let's get this part right. Now, privacy would mean four extremely simple yet basic things. What do they mean? They mean informational privacy, physical privacy, decisional privacy, and proprietary privacy. These are the four basic implications of the right to privacy. So what is informational privacy? See, informational privacy is concerned with your data protection, data encryption, data security, the secrecy, the anonymity, and the adherence to the Fair Information Practice standards. Now, this has been in the news recently because of the IT rules, and we have referred to the IT rules of 2021 for two reasons. One, because of the changes it has brought to the OTT regulation paradigm, and second is the rules which now make a compulsion or make an obligation, now very simply, to social media intermediaries, which basically says, I'll give you a simple explanation, which basically says that if there is a WhatsApp message which is being circulated across WhatsApp groups, and that WhatsApp message is sensitive in nature and could potentially cause communal riots or could also cause any other form of riots. It may have also caused any other form of riots. In such a scenario, the government can ask a WhatsApp, can ask a Facebook, Meta, can also ask an Instagram, can also ask a Twitter to release who wrote the message first, who sent the message first. So the whole concept of the first originator of the message becomes important. Who is the one who should be responsible for starting this sort of a viral ecosystem. And we must understand this is a reality of the country today. A lot of times protests, violent protests, clashes, violent clashes break out because of unverified, unreliable, completely fake WhatsApp videos or videos which are circulated on social media. And unfortunately, a larger chunk of these videos are either communally insensitive or they are caste insensitive, and therefore it causes a lot of rage on either sides of the spectrum. And of course people would demonstrate this kind of a rage, and a lot of times these outbursts are also fueled by the political fire, which therefore adds a lot more to the ecosystem. So the point that we're trying to make here is that who do we hold responsible? Who is responsible for causing that riot which happened because of a social media post? This could also be true for law and order sensitive areas like the north and the east. It could also be a problem for internal security in sensitive areas such as the Naxal affected areas. It could be anywhere. And when it is violating all notions of territory, of jurisdiction, because this is the cyberspace. The cyberspace does not have a start and does not have an end. So it becomes extremely difficult to apply criminal law to cyberspace. It becomes extremely difficult to apply criminal law to cyberspace. And that's largely what is the case with informational privacy. Okay? So for example, employers reading employees' personal emails without any legitimate purpose. Like for those of you who have worked before, or for those of you who are still currently working and preparing, on the side, some of you may have official email addresses. Now, these official email addresses can be monitored by your organization. The kind of emails that you're sending, the kind of emails that you're receiving, a lot of this could be done. And that could in fact be a violation of privacy. We'll come to this discussion in a fair amount of detail towards the end of Article 21 when the time is right. But the larger understanding of this is that this is a reality. Now, similarly, you have an issue with respect to physical privacy. Now, what is physical privacy? And you will understand that a lot of our original judgments, when we looked at, the MP Sharma case, the Dalmia case, when we looked at the Kharak Singh case, those were issues of physical privacy, which also means you have the right to be left alone. You have the right to be completely left alone. Today, this in the digital age translates to the right to be forgotten. And the Supreme Court has given very clear judgments that you have the right to be forgotten. Unfortunately, the implementation of that judgment is a problem. And I'll give you a very simple example for it. Like, for example, there were these cases, X versus YouTube, Y versus Union of India. And the reason they were called X versus YouTube or Y versus Union of India is to keep the identity of the petitioner, the identity of the victim, so to speak, intact, to secure it so that it does not cause unnecessary trouble. So in one of these cases, what had happened was an objectionable video of one of these people was leaked on the internet on several websites, including several pornographic websites. Now, of course, when the person found out, the person wanted these videos to be taken down. Now, the person approached the court and said, "This is a violation of my privacy. I don't want these videos anymore. We need to order these videos to be taken down." And that is how the Supreme Court said that your right to privacy also includes your right to be forgotten. And another word for forgotten is solitude. right? Now, solitude or seclusion or any bodily integrity are essential to physical privacy. And when we looked at the Kharak Singh and the MP Sharma, the Dalmia group of companies case, we understood it is concerned with complaints about unlawful search and seizure, peeping toms, trespass, and of course, ambush journalism, right? And for example, roadside sobriety testing is often considered a privacy issue, right? Now, for example, right for example I'll expect all of you to not ask me questions in the middle of the class, because I'm in the flow of a discussion, I'm in the flow of an argument. You wouldn't do that if you were in an offline class. So I would expect you to follow the same principles of decorum even if you're in an online class. It is extremely disrespectful and discourteous, not to the teacher, but to your other peers who are also studying in thousands of numbers with you currently live, right? So one must understand this. Anyways, so like for example, somebody is drinking and driving. This is a very good ethical example. So drinking and driving is a crime, right? Now, if somebody is drinking and driving, on one hand, it is an offense, and you're going to cause a lot of harm to a lot of people otherwise on the road who have absolutely nothing to do with you drinking and driving. And then if the police stops you and asks you to blow into a breath analyzer or to ask you to take a sobriety test, they are physically making you do something which you do not want to do. They are physically making you accept a crime or participate in accepting a crime which goes against your consent. And just in a few minutes from now, we will study about the right to self-incrimination in just a bit, and you will understand how this also has an implication on the right to self-incrimination or right against self-incrimination. But in reality, your right ends when my nose begins, and therefore if you're causing a larger damage to people around you, so your individual privacy could be subordinate to the collective security of the society that you are very much a part of. So physical privacy. Then you also have issues with respect to decisional privacy. Now, this is why I often say that while LGBTQ may have an interpretation and an interlinkage to Article 19, but the fundamental basis of LGBTQ is life and personal liberty. You have the right to decide who you are. That means you have the right to decide what your gender is, what gender are you attracted to, what gender are you not attracted to. You also have the right to change any of those variables, right? So it concerns about the rights of individuals, married couples and families to in fact direct their own lives. In fact, when we look at a heavily debated issue, right? Right? Correct. Yes, Nitin. Like a very common issue of, like, say, for example, marital rape, which is being discussed heavily over the last few weeks. If you see, marital rape is a combination of physical privacy and decisional privacy. Marital rape is a combination of physical privacy violations and decisional privacy violations. That even if the person is bound in the social contract of marriage, is bound by the institution of marriage, and several personal laws say that a marriage must necessarily be conjugal in nature. Conjugal means that the marriage must always have some form of physical intimacy between the people who are married, right? In fact, in some personal laws, even in Hindu personal laws, such as the Hindu Marriage Act, several times, you must understand this, that the lack of physical intimacy between a husband and a wife is legally grounds for divorce between the husband and the wife. And a lot of times when people are separated, they are not divorced, they're living separately, as a goodwill gesture, or sometimes as a legal tactic also. one out of the two parties often files often files a petition for conjugal rights, restoration of conjugal rights. This is a reality in India. So and that means you're basically asking the court to direct the couple to be intimate with each other. And that fundamentally, I mean, it sounds too hard to be true, but it is true. And that's a legal tactic a lot of divorce lawyers use to sort of create good faith that, we don't want to be divorced, we don't want to separate, so, we just want us to live together. So habitation petitions, conjugal petitions are fairly common in divorce cases. So they have some form of decisional or physical privacy implications in the matter. With respect to marital rape, the whole issue is that while I understand that proving it is going to be difficult, while I understand that identifying consent is going to be very difficult, and while I understand that there are going to be practical implications of there may be consent on a Monday, not on a Tuesday, but on a Wednesday, and there might also be issue of relative consent, that what exactly is it that the partners have consented each other to? Is it have they consented to a specific form of intimacy? Have they consented to all forms of intimacy? And so on and so forth. But at the end of the day, if a married couple are violating norms of consent in an ecosystem, in a setup, it is not considered illegal under Indian law. Unless, of course, it is a child marriage and it is at the option of the minor person in the child marriage. We've discussed this in the context of how age groups, marriageable age changes from 18 to 21 have implications on several other issues. Then we have issues of proprietary privacy. Now, the issues of proprietary privacy are fairly simple. It is the seizing of otherwise confidential information and personal identifiers, for example, data theft, for example, cyber attacks, for example, a lot of their people have their, like for example, when companies sell data, right? A lot of people are in the business of selling data. Let's say there's a new startup who wants to, nowadays you have a lot of these grocery delivering startups. Now let us say you open a new startup, which is a grocery delivering startup. Now as a grocery delivering startup, you would require a humongous amount of data, to essentially start sending messages or promotional emails to that, why don't you try out this app? It's in your area, and you would require very accurate form of data, that you would want data pin code wise, you would want data geographically. So what about the privacy of data then? What about the privacy of data in that context, right? So that's something that we must understand. That's something that we must get right. Okay. And then finally, we have what is called proprietary privacy, which in the other form of it also has something to do with the changes that WhatsApp had made very recently to its business policy. Now you see there are two kinds of data. One is called metadata and the other is non-metadata, right? So metadata is essentially information about people except their specific names, but information about people enough to profile people. Now we understand that WhatsApp, Instagram and Facebook are owned by Facebook, and Facebook is now called Meta. So, and WhatsApp also has a business side to it. A lot of people have business accounts on WhatsApp. So what WhatsApp basically does is this, right? It basically, now the policy says that WhatsApp can share the metadata of its users with advertisers on WhatsApp, with businesses that want this data on WhatsApp, so that they can send more targeted WhatsApp messages to people, because otherwise it's a free messaging platform which only uses consumption of data services. So somewhere it has something to do with distortion of a personal identity, and the government has asked WhatsApp to take back its policy, and currently WhatsApp has put its policy on hold. So you must understand that Facebook and Facebook owned companies in India are slightly at a back foot. Okay, they're slightly at a back foot because they've been under a lot of global scrutiny for the kind of work that they've been doing, for how inbuilt algorithms have largely, compromised the choice of people. There were reports on Facebook wherein Facebook was showing very politically inclined information to a certain set of people. Like, for example, if you were somebody who was right-wing, then you would be shown excessive videos, about issues with left-wing politics to strengthen your right-wing belief. So there's a profile about you. There is an identity about you, right? And always remember this, and you can use this in your mains answers, in your ethics answers, and in your data-related answers. It's a very common line, but I think it's a very powerful line. It is, if you're not paying for the product, you are the product. Okay? If you are not paying for the product, you are the product. You are the product. You are the product. Now understand what this means. And I'll be very honest with you. For example, when I do, most of the work that I do is free of cost, right? Students don't have to pay for their tests, they don't have to pay for their compilations, they don't have to pay for their notes, they don't have to pay for mental health support, they don't have to pay for a lot of the courses that I put on YouTube, and so on and so forth, and current affairs as well. Now, when you are consuming the information that I'm giving you, you are adding to my identity that, okay, he's somebody who has X number of thousand people on Telegram, Y number of thousand people who visit his website on a daily basis, views on YouTube are this much. Now, even then, I don't monetize any of my videos. I don't monetize anything in any form, because I think if somebody is watching educational content on YouTube, it should not be interrupted by random ads, which sort of distort the process. So I have a very strict principle on that. But when I get that kind of an identity, I'm able to leverage it with institutions that, listen, let him do what he has to do. He will continue to do this. And then institutions will then say, okay, he's an acclaimed teacher, he's a known teacher, so many people watch his videos, so many people follow his channel, and so on and so forth. So I'll be very honest with you. If you're not paying for the product, you are the product. Okay? If you're not paying for the product, you are the product. And that's something that we must understand this. And one must be honest enough to admit it, and must also be very honest to not exploit it, right? Which is why you will never see me doing anything commercial per se on my channels. Whatever is commercial, I'll be very clearly telling you this is commercial, this is not. But that's my personal moral code. But this is largely the ecosystem that data operates in. You are a data gold mine. I am a data gold mine. All of these are issues of data, of choices. And that is why privacy becomes a very important consequence of it all today, becomes very important notion of it all today. Okay, now, let's talk about the international legal framework on privacy. When we look at the international legal framework on privacy, though I haven't mentioned it very clearly here, but there is something called the GDPR, the General Data Protection Regulations. These are the most recent. These are the most stringent. These are the most exhaustive data privacy regulations of course, the European Union. And any company which is either based out of Europe or is working on data that comes out of Europe will have certain obligations under the GDPR regulations of the European Union. For example, some of you may still be using something called Skype. Now, Skype, I think, is a company which is headquartered in Finland. It's a Scandinavian headquartered company. Now, for those of you who've always been using Skype, check your account, your email account associated with Skype, and just type GDPR in the sub search column. You will see that Skype would have sent you an email saying, we are bound by GDPR and we need your consent so that we can process your data, and then we will require your consent if you give us to also use your data for business purposes, right? Okay, understood this? So that is how it works. That's the larger ecosystem, right? Now, once we're clear with this, there are some other sort of provisions that we look into. Article 7 and Article 8 of the Charter of Fundamental Rights at European Union recognize the right for respect for privacy, family life, home and communications. And it says that it must be, if you're collecting personal data, it should be for a specific purpose. And almost 80 countries in the world have enacted laws regarding privacy, including Australia, Canada, UK and South Africa. India, for a very long time, post the Puttaswamy judgment, still has been battling with the data protection bill. It still hasn't become a law, and let's see, it should become a law. But as far as the US is concerned, though there is no separate law and the term is not explicitly mentioned in the US Constitution, right to privacy is also seen as a part of your Fourth Amendment rights, which are the rights to basically protect yourselves. And especially in the US, when Facebook has been accused of certain activities of profiling people and using them to the disadvantage of people during elections, Facebook and Google and all of them have been held to very high standards of scrutiny by the respective parliamentary committees of the US. And I will give those examples to you when we do the analysis of parliamentary committees in just a few days from now. I have already covered the evolution of privacy so that you understand this beforehand. We will now look at some of the important ingredients of the efforts which have been made by the government, or some of the important measures that have been taken. What are the usual laws around it? Now, you see, most people, and this is what happens, 7 out of 10 aspirants will often talk about privacy only in the context of the data protection law. But there are actually several other laws which also have implications on privacy. For the purposes of this exam, I don't need you to know the technical details of the law. Nobody is going to ask you a question that says, examine the various laws which have effects on privacy. But when you're writing a larger answer or an essay on privacy, you can just name drop these laws with probably 1 or 2 lines about what this law is trying to do. So, for example, the Information Technology Act and the IT rules. So the Information Technology Act does provide for certain punishments, for certain safeguards in cases of data breaches, right? Unauthorized access of computer systems or any of those things. In fact, if anybody has wrongfully disclosed your data, sold your data without your consent, and a lot of those things have happened, then the Act also provides for compensation and jail time as a matter of fact, which is also where you must appreciate the efforts that have been made by a company called Apple, which has its own share of notorious histories, by the way. I'm not saying Apple is a fantastically moral company and they've not done anything that they shouldn't be proud of. In fact, there have been several allegations against Apple with respect to trademarks, patents, copyrights, with respect to anti-competitive practices, with respect to working conditions at their factories in China, with respect to employing underage children, minors at their factories in China. Apple has a bunch of skeletons in their closet, but that's not what we are referring to. What we are here referring to is that the most recent updates that Apple has made to its software systems, to its mobile softwares, to its iOS is that very specifically, we as users of these devices, you and I as users of these devices, can make a call. That suppose you download an app on your Apple iPhone or whatever it is, that will very clearly tell you, do you allow this app to share data with external entities? And you can decide on an individual basis whether your data, which has been used by that particular application, can be shared with the parent company or not. Now, that is a fantastic sort of an initiative by a private company, and that of course has helped Apple in its methods. It has also helped Apple in its ecosystems and mechanisms. Now, when you look at the IT rules of 2011, they also sort of look at protection of sensitive data, information such as passwords, bank accounts, etc., which is why a lot of times when bank frauds happen, you would have all heard of a movie called Jamtara, which was about, bank frauds and credit card frauds and account frauds. All of those were also violations of the IT rules. Just broad explanations that you need to know. You don't need to know the technical details arising out of it. Okay, and then we had the Sri Krishna committee report in 2018, which spoke of how we should have a fair data regulatory regime. This report, a lot of people will not remember, is actually called A Free and a Fair Digital Economy, wherein they actually gave a lot of very important terms. They said there is going to be something called a data principle. You and I are data principles. You and I are users of the data. And then you also have something called data fiduciary. Then you and I have also something called data fiduciary. Data fiduciary. Okay. Now let's understand this, and let's understand what are we trying to say. Data fiduciary is the company where our data is being processed at. It could be an Amazon, it could be a Flipkart, it could be a Google. And where is our data being stored? So it also has given certain concepts such as data localization, and all of these have been integrated into the draft of the data protection bill. Okay, so there's going to be a data protection authority, a law, and it also says that you should have better data protection regimes for your census data, for your Aadhaar data, and so on and so forth. My recommendation would be, don't get into the details of this bill because it hasn't been passed yet. And if there was to be a question on this, there would have been a question on this by now. We've already had a general question on the implications of the right to privacy. So let's hold on for something to happen in the context of current affairs for us to really worry about what this discussion is supposed to be about. And then of course you have your data protection bill. It has been pending since 2019. It basically provides a framework for safeguarding data. The fundamental problem that we will come to the problems, it says that you require consent from the user, which is the data principal, and after processing consent, can the data fiduciary process that data, sell it to somebody, or do it and use it for any other purpose. And of course, in case there is an emergency or a national security issue, then of course data can be used without consent. Now you see, we are moving towards e-governance. I mean, if you think about it, and I'll come to the provisions of the bill in just a minute, but think about it, and there have been several issues, and I'm not talking about the government. Now, let us say, for example, the Transport Ministry of the country, a few years ago, just about 2-3 years ago, the Transport Ministry of the country sold vehicular personal information of the people. Okay, right? नितिन, कोई बात नहीं, अगर मेरा मन कर रहा है 5 मिनट पढ़ाने का, तो इतना तो रिस्पेक्ट कर लो यार, इतनी तो तमीज रख लो, है ना? कोई इशू तो नहीं होना चाहिए, ठीक है? All right. Okay, and stop commenting in the class now. So for example, a few years ago, the transport ministry of the country had sold vehicular data to private automobile and auto insurance companies, and of course they made a whopping revenue out of it, but that could be questioned as a violation of data, because it's the government which is selling your data to a private player. Similarly, there have been issues of facial recognition, where the government has been thinking of using facial recognition technology. There have been issues on the custody and the security of Aadhaar data. There have been critics on it with respect to the Unique Identification Authority of India. So there have been several issues with respect to government as well. In health, you would have heard of something called digital health or a digital health ID. Now this means that your primary health parameters and your primary health information could over a period of time be integrated with an Aadhaar card, and therefore that one number will have all information in and around you. Over and above this, you're looking at any digitization provision will always have a privacy implication. For example, in internal security, we will look at CCTNS, which is the Cybercrime Tracking Network Division, and how you're digitizing criminal records, and the security of it is absolutely paramount. नितिन, अब समझ में आया कि क्यों मुझे ये पढ़ाने की ज़रूरत है? Because while science and tech teachers would have covered it from an analytical perspective, we are looking at it from an analytical perspective to the context of diversity, कि हमारे data related implications क्या क्या हैं, and does the bill really help in solving these kind of issues. Now, of course, the primary problems are that the exemptions of national security and all are not defined, usual problems with most bills in India. Second is that the bill says that Amazon data of Indian users must be stored in India. Right now, what happens is they are stored in massive Amazon data parks in Ireland, in some countries in Europe, in South America, so on and so forth. Now, India says that if you are having data, and India has a massive user base, so you should store data of Indians in India, to which the tech companies generally have an issue, saying that this is going to be too expensive. It is going to be very, very cost effective. It's going to be very cost ineffective, and therefore it is going to not be feasible. And they're requesting the government for certain. Sorry, Nitin, if I was rude to you, and it's going to be cost ineffective, and therefore it might also have an implication of financial prudence. So there is a lot going on. There is no clarity on this yet. And third, of course, is that it is the responsibility of the companies to inform the authority, and a lot of times they might not just do so, just so that they are protected. It doesn't cause impact on their stock market portfolio, and so on and so forth, right? So that is the larger issue. And apart from this, it also says that you should identify users which are insensitive in nature, which are using these provisions in a different context, which are violating the hallmarks of social media, and you're supposed to identify these problematic users and keep a track on them. So these are, of course, your larger issues with respect to personal data protection. Now, let's understand this in terms of इसको वापस कैसे जाते हैं, मुझे ये नहीं आता. Okay. Got it. Now, with respect to right to privacy, I think we've got most of it covered. In the notes, you will find extensive arguments and arguments based on ethics, on who should you really give the power to. Do you give the power to, say, a company let's say, do you give the power to technology, or do you give the power to government? Is the only way to control technology is to give power to the government, or is it that the only way to give power to technology is to control government, or the only way to give power to the government is to control technology? I've written these arguments for you primarily on the basis of ethics more than anything else, and this is where we were doing Article 19 previously. So I'll take you back to those discussions. So just a little bit of context. I'm not going to do these in a lot of detail with you. Just wanted to sort of share some very interestingly important arguments. Right. अब वापस कैसे जाते हैं? Right. Yeah. So let's look at the new OT. Probable question would be the implications of implications of the judgment on privacy. That's it. So these are the new IT rules. We've discussed both of them. I just wanted to put it together so that in case you get a question specifically on IT rules, because you've gotten a question on IT Act before, right? So these are actually called the Information Technology Intermediary Guidelines and Digital Media Ethics Code. There are two very important components. Here is intermediary guidelines. This is your Facebook, Instagram, Twitter, and your digital media is primarily your OTT platforms. So they've been primarily designed to empower the state and allow the executive considerable powers to sort of shape public discourses. This is the primary argument that people are making against it. Now, the basic genesis of this is that the government or the state is now demanding access to information about the content, the origins of digital communication that may have an impact to privacy, which we've discussed. And on the other hand, we are seeing digital content in itself, your OTT platforms, are subject to self-regulation, which is guided by the IT rules, and extensive surveillance is therefore designed to allow executive control over content. Now, there are basically these 4 questions that are asked, okay? And honestly, if this happens, I'll be the happiest, right? So let's understand this. These 4 questions are going to be in some form or the other used in paper 2 or even in ethics, or you could use them in your essays also. So there are 4 basic questions. The first question is, how do we negotiate, right? On one hand, our issue is hate speech, and on the other hand, we have an issue of freedom of expression. Because today, hate speech has also taken the shape of cyber trolling. Now, trolling can be against a specific person also, can be against a specific community also. So when you apply technology and digitization to these legal issues, what are the implications of it? Second, how can we build governance systems which are just, equitable, transparent, and do not leave ordinary citizens at the mercy of technology and the state? The idea is you want to create a regulatory ecosystem wherein it is the citizens who are treated fairly. Neither technology has too much power or neither government has too much power. A few years ago, I think it was the World Bank or the WTO, which made a statement which was, data is the new oil. And every civil service aspirant for the next 3 years in their mains answers wrote, data is the new oil. The reason they said is because at that point, the cost of data acquisition had become more expensive than the cost of what is called acquiring oil. Anyways, so that's the second question. The third question is, how do we make sure that there is actually some defined legitimate protection from surveillance for us? Because we understand that today technology is unavoidable. We live in the digital domain and we have no option but to to access it. And does anybody really get erased from the internet? Nobody does. Like for example, I have this very bad habit of sometimes just seeing what the internet has information about me, and as somebody who is in the public sphere, I must confess before you, I'm a very private person. So I do not like a lot of, I mean, I understand there are some social engagements that you would have and all of those things, but for most parts of it, I don't like social media at all. And it's not that I'm old school or something. I'm scared of it. I'm scared of how uncontrolled it is. But my question is, even with very little personal information that I have about myself on social media, there is still so much information. Half of them is wrong. Some get my age wrong. Some get some, according to some social media websites, I have 3 brothers and 3 sisters. My parents were not that excited as a bunch. Okay. According to some, I went to some school, some college. Somebody says I'm 100 years old. Somebody says I'm 50 years old. Everything is just all over the place. And even if I want to today, for example, say that I should not exist on social media, in some form or another, I will. I don't have an option, right? So how do we really protect the identity of a person in the world today? And then of course the larger question is, does the only solution to sort of curb the immense power of tech lie in giving powers to the state? Are these the only 2 options that we have? And these are questions that have become very legitimate in nature. These are legal questions. These are ethical questions. They're beautiful questions to think over and sort of have an understanding about. And therefore, the new IT rules have sort of brought back these discussions in public domain. Right. So that's that. Now, of course, when we look at companies like Facebook, Google, Ku is, I think, Indian version of Twitter, have, of course, shared details. Most of the companies, except I think Twitter, have shared the compliance that the government has asked from them, that if we ask for originators, you will keep sharing. But Twitter, of course, has said we're going to take some time and is looking for a better constructive dialogue. WhatsApp has filed a case against the Delhi High Court on grounds that this originator policy violates its customer privacy. Very ironical and hypocritical for WhatsApp, because on one hand WhatsApp wanted to share metadata with its parent company, and on the other hand WhatsApp says we have a problem if the government violates privacy. And of course they've been challenged by a lot of independent online media entities such as Live Law, The Quint and The Wire. They've written extensively on it. This is something we've covered in the censorship also. And then this is some data that you can use on how social media gets misused. I will not get into the technicalities of it, but for example, WhatsApp currently has about 340 million as a user base in the country, which is the largest in the world. Facebook has 290, Twitter has 17 million, YouTube has 265, Instagram has about 120 million people. Now, these are negligible numbers when you compare the total population of the country, but these are still numbers which are significant enough. If you can impact 340 million people in the country, that is still a significant percentage of population that we are getting into. There's of course a larger dependence of people on social media. There have been of course issues of defamatory content, issues of abuse, of hate speech, of trolling. And what happens is that the algorithms are designed in such a way. Like, I'll give you a very simple example. No matter, and this is something I get very honestly a little frustrated about, but I mean, there's something that you can't really fight. So everybody tells me you should make a video in Hindi, right? You should speak in Hindi and you should make a video in Hindi. You should teach in Hindi, or at least you should teach in a bilingual medium. Now, I have a problem with that, and it's not that I can't speak Hindi. I can speak fairly decent Hindi. I can speak communicative Hindi. For those of you who've met me in person, know that my Hindi is as Delhi gets. Now, my issue is not with that. My issue is when children are supposed to write the exam in English, and through the process of preparation, if they're not able to be fluent enough to understand and think in English, they will have difficulties writing in English. So through the process of learning in English, and I'll try to keep the language as simple as possible, you will automatically be more comfortable with the language. I'm not teaching students who are writing the exam in the Hindi medium. So if I'm teaching them in Hindi, I am violating what is the basic premise of information, right? So, but Hindi medium content is the most appreciated. That's my first problem. The second problem is you make serious content, serious aspirants like you will watch it, 2,000, 3,000, 4,000 views, and that's it, nothing else, and it's done. But I'm adamant, nay. But you make fun content, fun content goes viral, and fun content is the most appreciated. You give life gyan, you give content on, you make meme content, and you make that kind of a content. It will always be most appreciated and most respected, and so on and so forth. But serious content is not. It's because the algorithm works like that. The algorithm is designed in a way that it works like that. And it is supposed to, integrate, and it is supposed to sort of convey a higher pickup ratio, right? So that's also true for videos containing abuses or objectionable content. They get picked up more, they get circulated more, they get watched more, because these are very titillating in nature. These are very addictive in nature. I mean, the most reels that are watched are funny reels or objectionable reels. That's how a lot of people have really shot to a lot of popularity. There are a lot of people who've been on reality shows because they used to basically sit and give abuses, and the Supreme Court in Poonawalla versus Union of India in 2018 did say that the government should try and stop exploitative videos and all of those things as much as they can, right? Now when we talk about the whole originator issue, it's a twin problem. So companies have also said that, boss, for example, there's something called end-to-end encryption. Now, I'm not going to get into the technology behind end-to-end encryption. It basically means that the only two people who know that they're talking to each other online are the only two people, right? Even WhatsApp should not know what two people are talking to each other. That's called an end-to-end encryption fundamentally. And that is what secures privacy over technological communication or technology driven communication. Now, when something like this happens, when you have a law which compels a social media giant to disclose certain information about a certain set of people, if they're objectionable, while you're doing it for that one person, you're basically opening the chain of encryption. And the government says that, boss, we're not asking you to do it for every random person. It's not like there's an officer in the government who's going to tell them, right? Yes, like there's an officer in the government who's going to tell them that, listen, you know what, I want to know what my batchmates are talking about me. So I want to see, and you're in the IT ministry as a secretary, and you want to know what your batchmates are talking to each other about. So you will, call up WhatsApp and says, bro, I want chat details of my batchmates. I want to know what they think of me and what are they typing and writing about me. That's not why they're going to be using it, is what the government says. But given how Pegasus and all have been an issue, I don't know. It's a twin-edged game. But anyways, that's not the point. The point is the government very clearly says we are not going to be using it for randomized purposes. We are primarily going to be using it for very serious offenses with implications on national security, with implications on the sovereignty, on morality and decency and public order, and so on and so forth. And that's fundamentally why we're going to even get into something like this. Now, when you supply metadata, like the phone number or the timing of the sending of a message or the device that it was sent, you're essentially, creating some form of a violation anyway. Now, of course, WhatsApp's new policy has this. You were talking about it, but it's been currently put on hold. Then, of course, Twitter has the whole free speech argument. Yeah, which says that, boss, if I do this, then I am going to compromise the integrity of the users to say what they have to on Twitter. Like, for example, today the economic survey has gotten released, and I find it very funny that economic survey analysis videos start coming from today itself. It is almost like a like easily a 600-700 page document. It takes me 1 month to read it properly, see what is relevant, and it is not just a document which has facts in it. I understand that prelims questions come out of the boxes. I get that part. But the economic survey also is a fantastic policy document which has exceptional use in the mains exam. It really does. If you utilize it properly. I mean, if you do that, half the editorials that you read become irrelevant as far as the exam is concerned. The economic survey is that good. Unfortunately, in the last 2 years or so, the economic survey is not as unbiased as it used to be, but it still has relevant content. But I see a lot of my teachers nowadays, colleagues, अरे पढ़ तो ले यार 1 महीना, उसके बाद देखते हैं क्या सही है क्या नहीं है. And it happens every year. And what has happened is nowadays the UPSC industry has also become very close to like the news industry. It doesn't matter if you get it right. You have to get it. You have to get it first. And this is the problem with news also, right? It's not about you getting it right. It's about you getting it first. Really good news is you getting it right and you getting it first. But unfortunately, most people don't get it at all, right? Yes, ma'am. So that's that. Now, failure to comply with the rules and of course removal of this would put a lot of pressure on Twitter. Then we've of course covered the right to internet and so on and so forth. So all of this successfully covers our discussion on Article 21. Now in the next half of class, I'm going to spend a considerable amount of time discussing the Maneka Gandhi case, and then we'll be done with 14, 19, 21 and 14 to 21, and then we'll move to the other sort of rights. Okay, so you can take a 5-minute break, and then of course we're going to start with the Maneka Gandhi case. Okay, so let's start. So you can take a 5-minute break if you want to. And in the meantime, sort of read this in case you need to. All right. Govind, yes, it would be applicable only to the jurisdiction of of Delhi, but it would then be a sort of stepping stone to say further enactments by the Supreme Court. Now, see, there is also a legal strategy here. If you go to the Supreme Court and you lose, then it's very difficult going back to the Supreme Court on the same issue. The Supreme Court doesn't usually review its decisions in such a short span. But if you lose it one of the high courts, then you can always go to the Supreme Court on appeal. So that's the legal strategy. That's usually what we as lawyers often do. And that's a basic sort of human strategy, right? That you start small and then you make it big, right? Okay. Maneka Gandhi versus Union of India, ladies and gentlemen, 1978. Allow me the distinctive pleasure and the honor to walk you through this case, to teach you what happened in this case. Now, the facts are not relevant for the exam, but the facts are something that you must understand to understand what this case essentially leads to. So, the petitioner, the person, Maneka Gandhi, was a journalist. Okay, Maneka Gandhi was a journalist, right? Her passport was issued to her. Her passport was issued to her. Now you'll be able to relate some concepts from citizenship and passports also. Her passport was issued to her in 1976. Okay, and this is governed by the Passports Act. This is governed by the Passports Act, and the Ministry of External Affairs has regional organizations called the Regional Passport Office, which essentially do this. The Passport Act is dated 1967. The Passport Act is dated 1967. Right? Now, once we understand this, we understand the concepts of this. Now, what happens thereafter? In 1977, almost a year later, the regional passport officer of New Delhi, right? The regional passport officer of New Delhi issued an order or directed Maneka Gandhi, okay, to surrender her passport. Issued an order, wrote a letter basically, and issued an order to surrender her passport. To surrender her passport. Now, these facts are very simple, but the implications of these facts are massive. One, why was the passport asked to be surrendered? Two, does that affect on a person's right to travel abroad? And if you're restricting a person's right to travel abroad, is that a reasonable restriction enough? And does it violate 19 or 21? And third, the procedure under which it was done becomes, of course, rather pertinent. So it has implications on 14, 19, 21, and also has procedure established by law, due process of law, and a term called principles of natural justice, which gets used here. So when we look at the implications, when we look at what are the kind of issues that can be looked into, first, we could definitely look into an issue of Article 14, that under the Passports Act, why is one person supposed to surrender their passport and not the other person? So two people are being treated unequally before the law, or is why one person singled out under the law? So Article 14. Second, Article 19, being a journalist, you have the right to speak a certain way, to express your opinion. And if because of that, if you are restricted on your travel and movement, and you have the freedom of movement, does that affect Article 19? Third, it is a matter of personal liberty as to whether you want to travel in India, travel abroad. Does Article 21 come into play? And can all of the three be looked together, or are they supposed to be fundamental rights in silos or isolation? And then, of course, we had certain principles of the law. So these are some provisions of the law which are impacted, and there are some principles of the law which are also impacted. So, for example, procedure established by law. The way regional passport officer told her to surrender her passport, this is something that we have also studied as an application of Article 14. Second, is the law being used for the right reasons? Was the intention of the Passports Act to suppress the movement of travel of people? So, due process of law. And the fact that she was randomly sent a letter, there was no inquiry, there was no hearing, nothing at all. Does that basically lead to a term called principles of natural justice? So, principles of natural justice. And that's the beauty of our Supreme Court. And one could argue the extrapolation of the Supreme Court, which often gets into it. So, these are the implications. And if you want to, you can make a fourth implication as 14 plus 19 plus 21, or 14, 19, 21 independently. So these are the basic implications that arise out of this judgment that we must largely be looking into. Okay. Now, of course, this is a case against the center because you are challenging the order which is issued by a central agency, and of course the provisions of a central law. So the legal officer of the center is the Attorney General, and the Attorney General was representing the government here. And here, of course, you had several distinguished lawyers who were representing Maneka Gandhi. Now, apart from this, very interestingly, you had some fantastic judges who were a part of this. Just again, not relevant for the exam, but you may have heard of a very popular judge today in the Supreme Court, Justice Chandrachud. His father was also a Supreme Court judge who was a member of the bench here. You had Krishna, very, very well respected Supreme Court judge. You had Justice P.N. Bhagwati, who is known as, the father of public interest litigation in India because of, some coinages and certain terms that he has given in his judgments. And of course, you had, Kailasam and Ali and all of those other Supreme Court judges, but the big names, Chandrachud, Krishna Iyer, Justice Bhagwati, phenomenal judges in the legal history of India, right? So, of course, this was the case. I'll just show you something actually. Just give me a second. Beautiful book that I have called Court and Their Judgments on Arun Shourie by Arun Shourie, which also talks about the role that these courts have played and these judges have played, right? So anyways, so let's get into the arguments. Now let's understand what the arguments were, and let's understand what do each of these guys say. So what does Maneka Gandhi's lawyer say, and what does the government say? We'll do this like a debate, so it will be very easy for you. So the first argument, Maneka Gandhi's lawyer stands up to court and says, the right to travel abroad is a derivative or is an implied right under Article 21 because of something called personal liberty. That's the first argument, the first set of argument this person makes, and says that, boss, it says that no person can be denied this right except for procedure established by law, which means there has to be an exact method through which you can stop somebody from doing this. So it's basically A is to B is to C. You have the right to liberty. The right to liberty should give you the right to travel abroad, and you can restrict liberty and the right to travel abroad through a procedure. And if there is no procedure, you can't restrict that right. Now, the Passports Act does not give you a procedure. It just tells you that you can ask somebody to surrender their passport. It does not give you the procedure through which you can do it. So that was the larger argument, the details of the argument that were made, right? Second, and this is also extremely important, they said that the government has violated Article 21 by not giving an opportunity to the person to be heard. There is a right to be heard also. You did not listen to her side of the story. You did not question her side of the story, and you did not understand what she was trying to say, and you were basically just giving a judgment or telling a person what they should do without hearing both sides, without even a show cause as such. So that was the second argument that they made. The third argument that they made was that, boss, it was always the intention of the Constituent Assembly makers, which is why, remember, I told you, even with the preamble, you use the preamble to interpret the Constitution because it reflects the mind of the makers of the Constitution, which is why the Constituent Assembly debates are often quoted in courts to remind the court what the original intention was while making a provision in the Constitution. So the Constituent Assembly debates always wanted that 14, 19 and 21 should be looked at it from a common perspective, should be looked at it from a collective perspective, right? Apart from this, they also said that at the end of the day, what you are trying to do here is, by stopping her from traveling abroad, you are in a way detaining her in her own country. And here the detention is happening in the country, and there is a fundamental right against detention, and she hasn't committed a crime. You think that she may commit a crime, she may say something which goes against the interest of the country. So you have preventively detained her within the whole country. Like, the country becomes a jail for Maneka Gandhi. So there is an implication of preventive detention, which in this case seems to be arbitrary, and preventive detention is under Article 22. And there seems to be an arbitrary way of going about it. Okay. Now, apart from this, again, the arguments are not important for the exam. This is just to teach you what happened and how do we arrive at a conclusion. Apart from this, they also said that, boss, your principles of natural justice, wherein you should have a just procedure, a just law, a fair hearing, adequate time to be given, all of those things must be taken into account, and only when those things are taken into account should adequate action be executed. Okay, so these were the primary arguments that they made. Right now, the government comes in here and the government says, boss, we have our own arguments. Who says there is right to travel abroad? Who says? You say so. No, it is your interpretation. At no point of time has the Constitution implicitly or explicitly mentioned this at any given point of time. And if you want to travel abroad and you say something which affects the relationship of our country with that country, which will affect friendly relationships between the states, that is a reasonable restriction under Article 19 Clause 1, under Article 19 Clause 2. So I am allowed to restrict the right to travel abroad. There is no such derivative right as such. And second, while you are questioning the Passport Act was never intended to suppress fundamental rights. That's not the intention. You are making it up. You think that is the case, but it's not the case. And you must understand that this is a matter of national safety and national security. And it's the same argument. The UAPA sedition, same argument. That national security is an issue. So on grounds of national security, we may want to restrict a person's right to travel abroad, right? Third, you must understand this, and extremely important, that while you are talking about these principles of natural justice, one of India's first preventive detention cases, we'll come to preventive detention later, but one of India's first preventive detention cases is A.K. Gopalan, and I will talk to you about this case later. A.K. Gopalan basically said fundamental rights do not include principles of natural justice. Now, what are these principles? I'll come to them in about 5 minutes. Principle of natural justice is very simple. You have the right to a free and a fair trial, and you have the right for not having a biased trial. You can't be forced against yourself, the judge can't be biased, and so on and so forth. So none of this is in a fundamental right. This was a very narrow, was a very, very, a conservative kind of a judgment. Apart from this, the government also said this entire discussion on principles of natural justice is very vague. Anything could be an issue of principles of natural justice. Any procedure you could construe it as vague. Anything you could construe as unfair. So we can't base our decisions on something which is vague and something which is ambiguous in nature, right? And then we also got into further discussions where it says that, boss, Article 21 is wide enough to include 14 and 19. We don't need to look at them as a collective. It is okay. Article 21 is wide enough. That also means that it does not give you the leeway. It does not give you the benefit that, oh, if a law is violating 14 and 19, it must also violate 21. I understand that right to life and liberty means every other fundamental right. But the violation of any other fundamental right, alleged violation, does not automatically mean violation of Article 21. This is extremely important in that context. Extremely important in that context. Okay. And by the way, your Article 21 just says the procedure established by law. It does not say reasonable procedure. It does not say the procedure has to be just, the procedure has to be fair, the procedure has to be nice. No, nothing of that sort. Procedure is procedure. If the procedure is right, it's been passed by the parliament, end of story, you can go take a hike. So don't come and tell me whether the procedure is right or wrong. Clear? Understood this? So these are what the arguments, these were what the arguments that were made. Okay. Now, सुप्रीम कोर्ट ने कहा बोल लिया ना तू, अब मैं बोलेगा, हो गया तेरा, अब मैं बोलेगा, सुन लिया मैंने, नो प्रॉब्लम एट ऑल, ठीक, अंडरस्टूड, क्लियर, नो इश्यूज एट ऑल. Can anybody guess what the Supreme Court judgment would have been? Sorry, I'll give you a minute to copy this down. Now, this is happening in the context of post-emergency. The Supreme Court has to fight back for its reputation. They have made some very questionable decisions. So what was the judgment? The judgment was that firstly, the broad judgment that 14, 19 and 21 are correlated to each other and therefore can be looked at from a common perspective. they also said principles of natural justice is also the backbone of fundamental rights. It is implicit in India. And third, they also said that apart from procedure established by law, due process of law, which is questioning the intention of the law, must also be interpreted or must also be included. These are the broad, ये ज्ञान दिया सुप्रीम कोर्ट ने. उसके बाद स्पेसिफिकली क्या किया, ऑर्डर ओवर रूल किया कि नहीं बॉस, this order is wrong, this order has to be recalled, you have the right to travel abroad wherever you want to, however you want to, there is no issue. And the Supreme Court also then said that boss, the makers of the constitution for a reason discussed due process of law and procedure established by law. I understand the government's council point of view that we discussed them and there was a reason why I did not add due process of law. I understand that. I understand that this leads to vague questions on the law. I understand this. I completely understand this. But this does not mean that it is not a part of the process of it all. It is not a part of our evaluation of the law. So it said very specifically, it overruled the order. It granted the right to Maneka Gandhi to say that, okay, boss, you have the right to travel abroad. Now, this is all that you need to really know as far as fundamental rights is concerned. There are 14, 19 and 21 is concerned. You don't have to particularly get into the technical arguments here, but I will of course tell you what are the principles of natural justice. Okay. Now, I'll show off my legal knowledge a little bit, but again, not important for the exam. You know how we have ex officio, we have, ab initio, all of these Latin terms. So the principles of natural justice also have two basic Latin terms, and students of law will get it right. But you don't have to know these Latin terms, you need to know what the meaning of these words are. The first is Audi alterum partem. So, ये गाड़ी वाला Audi, ठीक है? Audi alterum partem. This is like a Harry Potter spell. And the second is Nemo judex in causa sua. Okay. Nemo judex in causa sua. UPSC में इसके बियॉन्ड कोई नहीं पूछेगा, मैं बस मीनिंग बता देता हूं. In causa sua. अब ये याद करने मत बैठना, दिस इज नॉट गोइंग टू बी आस्क्ड. इसको हम शुद्ध इंग्लिश में ट्रांसलेट कर देते हैं. Right? Let's understand what does this mean as far as our principles of natural justice is concerned. Now, it simply means, in one line it means, no one can be left unheard. No one can be left unheard. This is the literal meaning of Audi alterum partem. Okay. And second, no one can be a judge in his case. Pardon the gender connotation of his, because they've been written at a time where there was a patriarchal society. No one can be a judge in his case. Now, both of these principles mean so many things. This means the right to a free and a fair trial. This also means that legal aid should be a fundamental right. If a person can't afford a lawyer, the government should try and provide a lawyer to the best of the government's ability. This also means the trial should be transparent, the law should be transparent, it should be just. It also means no matter how heinous the crime is, even Ajmal Kasab gets a lawyer, every terrorist gets a lawyer if they are tried in court. You and I can disagree with it. I understand the rage, but everybody deserves a hearing in court. Even the perpetrators of the Nirgaya gang rape, the Kachua rape, the Muslim riots of 2002, the Babri demolition, the anything in the country which has really shook the pulse of this country and has gone to court. You deserve a lawyer, and you should always be given one in case you can't afford one, in case you can't get one. You want to be a lawyer in your own case, no problem at all. There are provisions where you can argue your own cases, but that's also why you need CAs, right? It's unnecessarily very complex, right? See, clear? No, Abhishek. The basic problem here was they applied what is called the doctrine of prospective ruling. The doctrine of prospective ruling, which they had also used in the 1967 Golaknath case, wherein any of these laws, any judgment of the Supreme Court will always have, any judgment of the Supreme Court will always have a future impact. A judgment of the Supreme Court cannot be predated. That is what is called an American concept of prospective ruling, which is why Maneka Gandhi's original order could not be cancelled, but in the future, this would still include the right to travel. So Abhishek Kumar ji, थोड़ा हम भी पढ़ के आते हैं, थोड़ा हमको भी समझ में आता है, तो थोड़ा सा हम पे विश्वास करिए, ठीक है? I will talk about the doctrine of prospective ruling as a part of the doctrine of basic structure when we look at it later. This is also why neither Kesavananda nor Golaknath nor Shankari Prasad Sajjan Singh, nobody got their land back. So we'll come to that later. ठीक है? So this is what is called Audi Alterum Partem. Okay, and then of course you have the Nemo Judex in causa sua, which basically means a few things, right? For example, you have the right against self-incrimination, which is also in a fundamental right. You can't be forced to give a testament against you, which also means that if the judge has a bias or a personal interest or a conflict, then in these cases, the judge must recuse themselves. There cannot be a judicial bias, a legal bias, a prosecutional bias. It has to be done in the most transparent manner. So as far as UPSC General Studies is concerned, this is more than enough. Yeah, Abhishek, I thought you wanted to get in touch with your law optional ना. एक बार मेरे को message कर देना. I'll talk to you about it. ठीक है? Clear? So, I'm very proud of you, Abhishek. A lot of people don't know the technical details of it. But anyways, so this is the larger ecosystem. This is how it works. This is your principles of natural justice. It basically tells you 14, 19 and 21 can work in cognizance. In the next few classes, you'll understand why this becomes an extremely important principle that we will apply on the doctrine of harmonious construction when we look at a conflict between directive principles and fundamental rights, where two directive principles 39B and 39C as per the Minerva Mills case are more superior or powerful than 14 and 19, but according to this judgment you also add 21, so there is a question on the superiority. So we'll come to that later. ठीक है? Understood this? Ravi, that the problem with the CGI Gogoi issue was there was no case. It was an internal committee hearing. Okay, understood this? Clear? Done? ठीक है, sorted. All right. Yes, Sanket, that is what is most heavily debated and in fact criticized about the whole Gogoi matter. Okay? All right. Thank you. We're done for today. भाई हो गया. ओके. ये स्टॉप कर दूं मैं? अच्छा, आप घर पे ही हो?